say that anybody who has been an employee of the company before the appointment of the director, he would not be considered and construed as an independent director. And then of course the list goes on. If some person has a material business relationship, that kind of person again will not qualify as independent director. If he is entitled to a stock option, the much maligned word in the West today and US, a lot of, I would say, corporate misdeeds are attributed to this whole subject of stock options and remuneration and perks. So if he is entitled to the stock options and things like that, apart from retirement benefits, because he has earned retirement benefits during the course of his employment with the company, and therefore we don't want him to be deprived of that. We say, okay, fine, that may be so. But if he is entitled to a continuing benefit like share option or performance-related pay scheme or things like that, that person will not qualify as an independent director. A close relative, and relative has been already defined in the company law. You are aware of that, probably section 214 of the law is there. Then there are past directorships which again will disqualify a person from being qualified as an independent director. A person holding 5% or more shareholding. And mind it, this 5% may seem to be very small, but in the Pakistan jurisdiction, this 5% has been there as a substantial ownership in the banking law for the last many, many years. At least for the last 30 years or so I can recall, this 5% shareholding has always been construed to be a major shareholding. And therefore, a person or an entity holding that and a representative of that institution will not qualify as an independent director with that kind of a shareholding, because that's a substantial interest. Then of course the creditors and institutional investors, well, they can always come on the board, and you know, the creditors and the special interests can come on the board under section 182 as nominee directors. They don't come through the route of elections. They'll continue doing that, but they will not be considered as independent directors. And even today the court says that these nominee directors are not to be considered as independent directors. And this is again a very important recommendation, that we want a sort of a cooling off period after 3 consecutive terms. We are not disqualifying a person. We are not debarring a person to come on the board, having served 3 years or more, 3 terms or more. But what we are saying is 9 years, each term of 3 years under the law is a good enough long period. There must be a break. He can simply come on the board continuously for many terms. But if he is there for the last 3 terms, meaning in general 9 years, then that gentleman or lady would not be construed as a dependent director. Now these are, apart from, let me just say, these are, I would say, more of illustrative nature. There may be situations other than that which, seen in the proper context, in the circumstances of each company, may perhaps be construed as disqualifying a person from being called an independent director. Because the principle-based provision continues to be there in the code, which says that the person cannot exercise independence of judgment because of whatever relationships that he has, whatever obligation that he carries. That principle-based provision continues to be there. This enumerative list is over and above that principle-based provision. So there could be a situation which could be hit by that principle-based provision, and each case will be seen on its own merit. Well, gentlemen, I think we'll break for Maghrib prayers this stage, and inshallah, once we reconvene, I'll continue with the remaining part. Thank you. Okay, ladies and gentlemen, we are back to work again. Those of you who are there would obviously find this a repetition, but those who have just joined, let me apprise them that we started off with a recommendation with regard to the composition of the board in terms of balance between executive and non-executive directors, and in that the recommendation is that executive directors be not less than 2 and not more than 1/3 of the directors. Banks and DFIs will follow their own regulations under the prudential regulations anyway. Then we have recommended that there should be independent directors of the board whose number should not be less than 1/3 or 3, whichever is higher, of the total number. And then we dealt with certain criteria or certain circumstances in which a person, if he is struck by that, then he will not be deemed to be an independent director. Nevertheless, he will be entitled to come on the board anyway. So this is what we had covered before the break from our repairs. Another very important recommendation, and again this was one which was debated at length at the time of the original court, but for different reasons, different sort of viewpoints, it was just put it in a very mild form by saying the chairman shall preferably be a non-executive director. Now it was as good as saying, chairman preferably a non-executive director. It was not very emphatic, it was not very, I would say, definitive. This time what we are saying is, and by the way, the prudential regulations does say that the chairman of the board and the CEO shall be two separate persons. This is already there in the prudential regulations for the last many, many years. Exactly the same principle, separation of powers, a balance in the board for checks and balances. We are saying the chairman and CEO shall not be the same person. Now this time we are not saying preferably. This is mandatory. Apart from the situation where, as you know, some of the public sector corporations, when under their respective statutes, the chairman and CEO are one and the same person. Now that will be a legal problem. Our recommendation to SCCP would be to take the proper initiative and move to the government that even such statute be brought in line with our recommendation. Because oftentimes, now if you ask me, is this going to make a world of difference in terms of governance? My own answer would be yes, but there could be a viewpoint where you say, well, there are certain corporations where if you separate chairman and the CEO, and I don't want to name a corporation right now, we are a very prominent corporation in the state, in the public sector. When this particular thing was separated there was quite a tiff between the two. And even in the recent past, you must have read in the papers, a public sector corporation, rather not a corporation, it was a different form of entity, where we read in the papers, it was reportedly said that the chairman and CEO are not getting along together. So we are not the ones who like to share power with anybody. Culturally, by nature, sometimes this is the situation. But if you look at it from the principles of corporate governance and as the best international practice, separation of the office of the chairman and CEO has much to come in itself. And this is exactly what we are recommending, that apart from statutory limitations you have, the companies in the public sector, in the listed sector, shall have two persons as chairman and chief executive separately. And that chairman shall be a non-executive director, meaning he will not be an executive chairman. He will be only the chairman of the board. And obviously, as you know, the CEO has to run the company, the chairman has to run the board. The chairman has to manage the board, the CEO has to manage and run the company. So these are two very, very distinct roles, and the board shall decide as to what shall be within the domain of the chairman and what shall be the responsibilities of the chief executive. So we are left it to the board. We are not being instructive or prescriptive here. We have said that the role of chairman and CEO shall be determined by the board in the individual circumstances and context of the company. And again, this particular requirement, if at all it goes through the way it is recommended, shall become effective and applicable to the next board when it is reconstituted. You will recall that in 2002, at that time, a person could be a director of endless number of companies. Indeed, at that time, you saw that a few people were on more than 1.5 dozen companies. But at that time, you would appreciate that a member of the board did not have the kind of onus and responsibilities which he is expected anyway to discharge. And that kind of endless number of directorships, I think, makes it beyond any normal human being to discharge his responsibilities effectively. I keep saying there is no magical number, there is no particular sanctity behind a particular number, that 10 is wrong and 5 is right. But if you just go by the sheer amount of work one has to do as a due diligent process in terms of his role as a director. You have to have 4 board meetings anyway as mandatory. Then you have committees. Then you have the quarterly and half-yearly accounts which must precede every release of financial statements. And if you count all those, at least 6 to 8 meetings per company. And if you are a director of, let's say, 10 companies, which is the present situation, it permits that.